All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here. 540-0580 is the talk line. Just want to let you know we have a table down at the Lancaster County Women's Expo at the Spooky Nook Sports Center at 2913 Spooky Nook Road, Manheim. So if you're out and about and you want to stop by, Shane's down there handing out goodies. And we've got some giveaways. So stop in at the Lancaster County Women's Expo. Again, that goes till 3 p.m. today. My buddies at CDL Labor Logistics are seeking experienced, qualified commercial drivers with clean records. For long-term high-paying positions as a driver, both local and regional, PA, Maryland, New York, New Jersey, and the general area, call 866-293-1880. Again, if you're a CDL driver, you're looking for a high-paying job, call 866-293-1880 and tell them Carl sent you. And again, I want to thank Harrisburg Beer and Cigar for letting us do a little gun lecture in their lounge last week. We had a great group in there, lots of very interesting people. In fact, a couple of the regulars who are just in there to smoke cigars on a daily basis chimed in with some great material. So we had a wonderful conversation. That's Harrisburg Beer and Cigar over on Union Deposit Road. If you think of a beer distributor and cigars and you're thinking of a little cabinet or something, imagine $500,000 worth of cigars in a giant walk-in humidor. It's as fancy as any cigar shop you've ever been to, so I recommend you stop in there. And the selection is top of the line, and they pride themselves that if there's something they don't have that you like, they will get it for you. 540-0580. Lisa, you're on with Carl Rominger. What's going on?
Hi. I have actually thought about calling you for several weekends now. I actually called your Carlisle office 2 weeks ago, got a return call from one of your colleagues, but did not follow through. So I'm just looking to get some advice. I have a 9-year-old child who went in first grade when he was like 5, diagnosed with ADHD.
Right.
I fought the medications and such. I'm in the medical field. But unfortunately, after exhausting all my routes, he did go on some medication, and he's been on that medication for over 3 years now. But over the past year, he has developed what they call tics. It's a kind of like Tourette syndrome.
Okay.
The first two tics were all motor, like maybe eye twitching and such. Pediatrician suggested, you just have to ignore these tics. They'll go away, and they did. But since January, the second week of January this year, he developed a vocal tic. It's like a nonstop, excitedly, loud at times grunting.
Okay.
I've had very nasty emails, text messages daily, contact from the school because my son's been removed from the classroom for this behavior because it's disruptive. I actually stopped his medication about 3 months ago with the pediatrician knowing because it was a stimulant. I joined the National Tourette Association, and I even told the school system about 3 months ago they will send somebody out to educate people on this. My son's been bullied. I've informed the school. I filed a 504 plan a couple months ago because of this. But some of the things we have in the 504 plan about him being not removed from the classroom apparently has been still occurring. Now, we removed him from his medications. I was hoping that the tic would go away, the stimulant. It never did. And then I was still getting nasty emails because he was so far off his behavior, but there's a lot of stuff associated with everything this kid's been going through. Needless to say, he sees a pediatrician neurologist at Hershey. He sees a behavioral therapist pediatrician, also his normal pediatrician, and he goes to a psychologist.
Right.
All of them have had contacts. I have been writing letters from the teachers basically saying, you have no clue what we go through. We're so sick of you, medical providers and psychologists telling us how to do our job. I've asked the principal through emails to please, can we get together? No responses.
Okay, so let's sum it up here. What basically you're saying is your child has a medical issue which is making him somewhat disruptive, but it's also the sort of thing that causes other kids to tease and bully him. And the school is not only not adequately addressing it or working with you, but seems to be working against you. Does that seem adequate?
Absolutely. And they're just getting the more hands in the pot as far as his medical profession, which is the help he needs for this. They're just getting more upset with it.
Is there...
His teacher that he has is actually what upsets me the most. I felt so confident. He's been in the school educational system for 40 years. He's retiring in 2 weeks, along with the principal of this school district is retiring. So it's like they just don't care.
Right. So long and short of it is, have you gone for an IEP, individual education plan?
I did not. I filed for the 504, the IEP. The reason why we haven't gone through the IEP is because, number one, from what I understand, the neurologist, a lot of that has to do with individual, very in-depth testing, but he does not have a learning disorder. He just has this tic that has developed. Right. And from what I understand, in our 504 plan, per the pediatrician, the behavioral therapist, her big thing was the teacher needs to remind him to breathe, all kind of stuff. But then I went to the neurologist, and she's like, no, you don't do that with Tourette syndrome. You need to forget it. The emails will tell you, I used to think it was me, but the tone of it is very just like they're annoyed with it. My son even went 2 months ago to the nurse's office and begged the teacher to address the class while he wasn't there to let them know he is not doing this on purpose. And again, I begged to letting somebody come in and educate the school on this, and they've never followed up through it. You know.
So do you feel that they're not adequately addressing or creating a 504 plan? Is that?
Yeah, because what I found out from the neurologist with my son for the first time in the 504 plan, SATs occurred about 3 weeks ago, and per the 504 plan, the doctor suggested my son needs to start in the classroom every day for testing. If the tic behavior becomes disruptive, then you can remove him, which they followed through with that as best they can. But then my son told them that there are times in the morning
right.
and in the afternoon that he's been asked to leave the room, and we didn't know that.
Okay. Well, it seems like you may be at a point where if you're not getting adequate redress from the school, you may need to seek legal counsel to try to enforce.
Can I just tell you, we had a follow-up to the 504 about 2 weeks ago, 2 Fridays ago, and Jacob, I shouldn't have said his name, my son's been put on medication. We've stopped stimulants, but he's been put on a medication that actually helps with the tic, and It does have a focus type aspect to it. And from what I hear the last couple of days, it has been much better, but my concern is this. This may not be the end of it.
Right.
He's going to be going into one more year of this school, and I specifically said at the 504 plan 2 weeks ago, I need to know legal aspect on your end of it. What are you guys going to provide for my child? Because when I talk to National Tourette Syndrome, they say 95% of it is not legally or ethically right to remove a child from a learning environment unless it is truly, truly disruptive. It cannot just be annoying. Right. And they never answered me. And I then proceeded to ask them, have you been in this situation before where you've dealt with this? And I don't think they have. Nobody answered me.
Right. Well, I don't think anybody knows how to deal with these things unless they've been through them before. So my advice is monitor the situation and strongly consider involving legal counsel. All right?
Okay.
540-0580. We're going to come back from the break. We'll talk with Ian and get down to business here.
Talk that stimulates your mind. WHP Talk Radio 5.
That's 1-800-382-9358.
Let's return to Weekend Appointment with Carl Rominger on WHP 580.
Oh, boy. So I was in Sheetz today on the way here, and I picked up a little placard they're handing out there called Free My Beer. It's freemybeer.com. And it's all about, making beer available in places like Sheetz. Imagine that. But what I was kind of annoyed about, because I like the concept, Free My Beer, reform these crazy liquor laws. They're not really going to reform the liquor laws. Whatever they create is going to be a boondoggle. Just take my word for it. Doesn't matter what they do. Too many vested interests, too much money. But I go to the front of the site, and I have to put my age in because I have to be over 21 to go to freemybeer.com. Now, it's not a site selling beer. It's not a site promoting beer. It's a site promoting your rights, but apparently if you're only an 18 or 19-year-old, you don't have any rights to promote, according to freemybeer.com. Very disappointing, actually. And I'm sure they're going to say, well, it's an alcohol site, and we felt we have to... No, it's a rights site. And if a 7-year-old or a 17-year-old or a 70-year-old wants to get on there and exercise their rights, you shouldn't have a damn age thing on it. Ian, you're on WHP 580 with Carl Rominger. What's going on?
Hi, Carl. I got into trouble in 2011 and had to do 6 months in jail. I got about another year of parole and probation. Now, because of all this, I lost custody of my son.
Okay.
Now, he turns 12 on June the 4th, and he's begging me to come back and live with me again.
So,
do I have any way of being able to get him back?
The 6 months you spent in jail, was it for child molestation or was it a DUI?
I had suffered a psychotic break and had a minor run-in with the law.
Okay. Well, the answer is, depending on what your conviction was for, you may have to go through a counselor and get a certification, and because it also involved a psychotic break, I would definitely think the judge would want to see.
Well, I've been on medication. See, it was related to a stroke that I had.
Yeah.
So I've been on medication since 2011 when they finally figured out what was going on.
What was causing it. And by the way, it's interesting.
I haven't had any problems.
It's interesting because when I was talking to the homeschoolers the other day, I'm going to call them forever the homeschoolers. I actually mentioned that to him. I said, we have this interesting thing going on now in the law where we've said, for instance, that we have a veterans court where we recognize that people have PTSD, and that may be what caused them to act out. But then one of the mothers, I think, asked a fine question. Well, doesn't that treat people unfairly when you single certain people out and treat them differently in criminal court because they were a veteran or because they're an addict or whatever their status is? And I said, it is kind of true. And I said, here's an example of somebody that doesn't get any help. It's people who have mini strokes or strokes, which cause brain damage or vascular, issues in areas of the brain where certain inhibitions might be lost or behavior becomes radicalized. And, we like to believe that we punish people for what's in their heart. But really what's in your heart is really controlled by what's in your mind, and what's in your mind is really controlled by chemistry and blood flow.
Yeah, see, I suffered they call it it's in the stroke category, intracerebral hemorrhage in my frontal lobe. And the frontal lobe is where all your cognitive thinking and reasoning and stuff is at. And it was just a minor goofy thing, the cops wanted to pull me over for something, and I just got spooked. I had no reason to run, but I got spooked, and I took off like a bat out of you-know-what.
Right, and what happened is, and it's interesting because, again, we always want to punish people for what they did, but it turns out that we're at the mercy of our organic brains, and the reality is some people don't have control over what they do, and so the next question is, what's the point of punishing them if it's just a brain chemistry problem?
Yeah, see, I don't have any money. I had to rely on a public defender who did not fight for me whatsoever. I mean, it was a big joke. All he did was escort me through the system.
And now that we know you have, are you still on probation?
Yeah, I'll be off in February 2014.
When were you sentenced?
I was sentenced for the first offense November of 2011 and February 2012.
Gotcha. So your convictions are definitely final, or more than a year final at this point. Which puts you out of the PCRA category where you could try to reopen it on that basis. That said, you should be fine in custody court. You want to get a custody lawyer. We want to do a couple hoop jumping things, but you absolutely have the ability to get custody back.
Okay, because is he old enough to say, hey, I want to go live with my dad?
His say counts for a lot. It doesn't control, but it counts for a lot. All right?
Okay, before you hang up with me, the lady that was just on with you, if I may just say something to her real quick.
Yeah, go ahead.
Ma'am, you are your best and only advocate. If you do not stay on top of it, nobody else will. I've been through it with my son. My son's a special needs student. and you are your own advocate, I had to fight tooth and nail with CBHMP to get help for him in the classroom.
Right.
And maybe she might want to check with that, have a TSS with him in the classroom.
Gotcha.
That might be able to help that.
Yeah, and that's I was kind of thinking that she may be getting the point. The schools will not. It all costs them money. So at the end of the day, they're trying not to spend it.
They don't care. You're your only and best advocate. If you don't fight, nobody else is going to fight for you.
Ian,
you got to stay on top of it.
Come see me or go see another lawyer about custody, okay?
I'll give you a call sometime. Thank you very much.
All right, boss. 540-0580. Mike in Colonial Park. What's going on?
Hi, Carl. How you doing today?
Good.
A quick question for you on identity theft. What I'm trying to understand is when you get your credit report and you have an item on it that you're not responsible for, why shouldn't you be able to notify the credit bureau and then them be obligated to remove the disputed item from the report and then them notify the creditor, and then the burden of proof is on the creditor to prove you did execute the transaction? That's what I've never understood.
Repeat that so I follow you exactly. You're saying that...
What I'm saying is I get a copy of my credit report,
right.
Say. I see an item on there, and I say, that's not mine. I had nothing to do with that.
Right.
Now, I notify the credit bureau.
Right.
And now, in my mind, they then, where I understand then you go through a dispute with them. But what I don't understand is why don't they have to then remove the item, the disputed item, from my,
well, they have to remove, if you dispute an item, they're supposed to remove it, and then they're supposed to recheck with the source.
Right. And
if it's revalidated, they can put it back up.
Okay, but the burden of proof, what I don't understand is how people get in trouble with this. Like, because there's no way the creditor, if you didn't do it, there's no way the creditor can prove you did.
Well, right, and if it's one that isn't yours and they do that, then you ultimately may have recourse against them under the Fair Debt Collection Practices Act.
Oh, I see, okay.
Yeah.
Yeah, that's what I didn't understand about it.
All right, boss.
Okay, thanks, Carl.
All right, bye.
Bye.
Let's see what kind of time we got. We got 5 minutes, so we can take a few more calls here. By the way, I'm going to have Lisa Grayson on later. She's a JAG attorney who's running for Register of Wills in Cumberland County. And her opponent I've also invited on for equal time. So we'll talk more about that when we come back from the break. And we'll also see if we can get my mom on here again today. I always like calling her on the weekends and see what she's up to. Jonathan, what's going on, brother? Hey, Jonathan.
Hi, Carl.
Yeah.
I had a question concerning statute of limitations.
Okay.
My aunt, about 10 years ago, had an addition built on to her home. And just in the last 2 weeks, they were having flooding issues, and we ended up drilling through the foundation and found that the foundation was put in completely wrong, and corners were cut, including with some of the supports in there. Just everything was not up to code. And we know who the contractor is, and we want to confront him about that. But I mean, it was 10 years ago, so can we still go after him legally for these really poor building practices?
The short answer is maybe. Let's see what the applicable statute of repose is. Because it's not really a statute of limitations that you're worried about. Okay?
Mm-hmm.
And so the Pennsylvania statute of repose affords some relief to contractors builders. It's 12 years after completion of construction or improvement. And so a statute of repose means that if you didn't discover the problem within 12 years, you can never sue the builder. But your 2-year statute of limitations for negligence and your 4-year statute of limitations for breach of contract begins to run when you discover the problem. So basic way of explaining that is if you discovered the problem in year 1, okay, then you've got 4 years to file suit. If you discover the problem in year 13, you can never bring the lawsuit because you're past the 12th year.
Okay, but I've discovered the issue in year 10, so...
And you should, so as long as you move promptly, you're still within 12 years for the statute of repose.
Excellent.
And that's 42 PACSA 5536, but what I'll do is copy that and put that on the Rominger and Associates page on Facebook here real quick. Sorry. All right?
All right, excellent. Thank you very
boss.
much.
Good luck.
Have a good day.
Okay. Well, yeah, the statute of repose, just so you understand that, the idea of a statute of repose is I don't want to build something and worry about having to be sued 100 years later. So the legislature's basically said, here's a statute of repose. Now, I want you to think about it for a minute. It kind of makes sense. If you don't discover the problem for a really long time, it might be a real problem, but odds are if it goes hidden or never causes a problem for a really long time, then it can't be the worst problem in the world. So the theory or the public policy behind that is that is going to present itself very quickly. It's going to become a problem immediately, or at least within 12 years. The balance there is to protect you, the builder, or the person who provides the property in the long run. On the other hand, the statute of limitations says that once you know about something as the person who wants to sue, you need to move promptly with it. Want to talk about barking dogs? What's going on, my friend?
Oh, hi, Carl. I was just curious. I've spoken to the police a few times about this, and it looks like they're going to be more responsive in addressing the barking dog issue that I have with a particular neighbor. But I did have a question. I failed to ask them, and I don't know if they would have even given me this information. Is it legal to take video and or audio with a camcorder of dogs out in someone's yard barking?
Yes. There's no there's no expectation of privacy. So if the dogs are outside barking and you walk outside and videotape it. Now, if you have to climb a fence and hang off a rail sideways, then there might be an expectation of privacy.
Okay. And so that next question, of course, you just answered, would be the legality of it. I guess it is legal. And next would be, is something like that admissible? Let's say the guy got a citation, he wants to fight it, and you go to the district magistrate.
Yeah, it would be admissible.
It would?
Yep.
Okay.
You need the person who took it, however, to lay foundation, if that makes sense.
I'd be doing it myself, more than likely.
All right, boss. Good luck.
Okay, thanks a million.
540-0580. We'll be back.
The smart choice. Let's return to Weekend Appointment with Carl Rominger on WHP 580.
Hey, I want to give a big shout-out to the Soccer Shots program. So if you've ever heard of that, it's for the little kids to learn how to play soccer. My son, who will be 4 in November, just completed his first program, and I put a picture up with his little medal today. And he was quite proud of the medal, and he wouldn't let go of the paper certificate that they gave him for about an hour and a half, which I was quite sure he would mutilate or spindle or fold or all the things you're not supposed to do to a dollar bill. And no, he didn't. He didn't even drool on it or anything, so quite amazing. 540-0580. Steve, you're on the air. What's going on?
Not too much. How you doing this weekend?
Good.
Good. I had a question for you. I guess pretty much what it was what kind of statute of limitations there would be as far as child molestation, and I guess the criminal statute of limitations and civil as well.
Off the top of my head, I think the criminal, I can't remember what the criminal's up to, but I think it's way up there, and the civil's up to at least 50 years, I believe. So long and short of it is pretty much if the act happened ever, and I'm trying to remember the cutoff date, because there was a time when they moved it up to 12 years.
Okay.
And then if anything hadn't lapsed in that period in there, and then it got extended again. So I would say you're working with, and I'll look these up here during a break, so I can give you the exact figures. But basically, in the current climate of statute of limitations as it applies to sexual abuse cases, civil or criminal, there is many, many, many moons after the 18th birthday when the statute begins to run. So they didn't begin to run until then. So it's extensive.
Okay, so something I guess 22 years ago would still probably fall within that.
What year was that? That was
let's see, what, back from now?
You got to go 13 years back to 2000, right?
All right.
And then you got to go 9 more years. So you're looking at what, 1991?
Correct.
So yeah, that's somewhere in that date. So I'll get you the full analysis during what I'll do. During the next break here, I will pull up the little chart that I found and take a look at it, because that's the best way to do it. It gives you the cutoff dates and the time. Okay. And actually, what I can do is post it on my Facebook page if you want. And then you'll be able to look it up and do some exact calculations.
All right. Now, when you were saying about the 18th birthday and stuff like that, is that like when the clock starts to tick? Or?
Correct. Anytime somebody's injured, hurt, or has a cause of action, it begins when you know about it or should have known about it, unless you're a minor, and then your statute of limitation tolls until you're 18.
Okay.
So if you had a car accident, you have until your 20th birthday to bring suit if it happened before you turned 18.
Okay.
That makes sense?
Yeah, I follow you.
And it does become an issue sometimes. For minors, it's easier because if we get a traumatic injury case, we have a few over the years, we have a minor with traumatic injury. With an adult, we have to file suit within 2 years. So if we're waiting to figure out how the person's going to pan out and see if it could be settled without necessity of a lawsuit, that 2-year limit sort of forces you into court sometimes. But with a minor, if you have a 10-year-old, for instance, then theoretically you have 10 years to figure out where you're going to be.
I gotcha.
All right?
Okay. Yeah, I guess pretty much the incident had happened, when this person was like 12, 13 years old. And then, that would have been...
Well, if you're saying that was 19 years ago, right?
Well, that was in 91.
Right.
And that was...
and they were 12 or 13 at that point.
Correct.
So their statute wouldn't begin to run until they turned 18. So if they were 12, then we would actually be looking at what the status of the statute of limitations was in 1997.
Okay.
All right?
See
how that works?
I follow you.
All right, brother.
All right, you have a good weekend. I appreciate it.
All right, my friend. 540-0580. The Supreme Court of the United States just put out a ruling the other day about planting seeds and patent violations. Monsanto makes a soybean that's Roundup resistant. Apparently, 80-some% of all the soybeans planted in the world now are Roundup resistant with this gene that Monsanto owns in it. So what this guy did was he started going around and just buying seeds, not planter seeds, but the ones that were going to be actually used in production. And so he bought those, and then he did something with them, planted them a few times or something to create a few generations down. And then Monsanto sued him saying, you're using our Roundup-resistant gene and you're spraying your field with Roundup, which proves that's your whole purpose in doing this, and you're not buying the seeds from us, so you're not paying the royalties on the gene. And a unanimous United States Supreme Court said that is a violation of Monsanto's patent. What they left open, though, is inadvertent. And they said clearly this guy had done it for purposes of circumventing paying for the patented seeds, and therefore he was clearly guilty. But the interesting question will be, what happens when transgenic situation occurs where a patented gene makes itself into the wild population or becomes so ubiquitous in the population of a plant or an animal that you couldn't, for instance, raise a turkey without it having some gene owned by somebody in it. And they left open a little wiggle room in the lawsuit for that, but it's kind of interesting because, because a lot of farmers are running into that. For years now, people have been going around looking for people who are using seeds they didn't pay royalties on. What this guy had done, because he was saying that the ones that he was growing to sell were many generations down the pike, and I think that was the deal, was he wasn't just planting the seeds that he saved. Because, farmers can't save seeds if they want to plant them, because when you plant certain crops, you're not allowed to save the seeds, again, because those are owned by the corporation in charge. 540-0580 if you want to get on the air here. Let's see if I wanted to hunt my mom up. Let's see if we can find her. I just like to dial her.
Call has been forwarded to an automated voice system.
Let's leave her a message.
Signe Rominger.
Oh, it's definitely her.
Is not available. At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options. To leave a callback number,
Should I tell her I was in a really bad car accident? Hey, Mom, we were trying to get you on the radio. Call my cell phone if you get a chance, and we'll figure it out. Love you. Bye. All right. We'll leave it short and sweet. If her cell phone's not on now, who knows? Let's see. Oh, I'd have to do something else here. All right, what am I screwing up with the phone here? All right. What did I do to the phones? Anything? Oh, key's ready. Okay. Dave, you're on WHP 580 with Carl Rominger. What's going on?
Hey, Carl. How you doing?
Good.
I've been studying this Jody Arias case January.
Yeah.
And I see some similarities between your case with Sandusky and you and Joe Amendola. I understand you tried to get off the case the last bit, and Jennifer Wilmot and Kirk Nerman you're trying to get off, but the judge won't let them off the case.
Right. And there's legal precedent for the theory that lawyers can't get off a case because it interferes with the administration of justice. But there's also a theory that if a lawyer has a conflict or a health problem or is otherwise not competent or fit, they should try to get off the case. And we ended up in a pretrial filing that was eventually unsealed, basically saying, hey, we're not ethically able to represent the client because we're not adequately prepared because you guys have crammed us into this short little time frame. Did you also notice that Curley and Schultz still haven't even had a trial date yet, right?
That's correct. Yeah.
Imagine that. So that was our position, and the judge said no. So that could be fundamental error to force somebody to go to trial with attorneys that are unprepared. And I got to tell you, that wasn't something that either one of us said lightly to the court. I mean, we didn't put our signature on there and go, ha-ha. We put our signature on there and said, holy smokes.
Had a real loser there you were dealing with, the same as these two attorneys out there in Arizona. Let me ask you one more question. On this O.J. Simpson, I've been following that on the court TV, and he's saying that Gail Galanter didn't tell him about any type of deal or anything.
Right.
Galanter's now saying he lied about all of that. He told him all of that. Do you think O.J. Simpson's going to get a new trial?
Well, here it's a credibility question, and so when O.J. says he didn't tell me about it, and the lawyer takes a stand and says, yeah, I did tell O.J. about it, the only thing his new lawyers have to work with is, did he document that he told him about it? And so usually if I have a good plea offer, I would like to send a letter to the client saying, here's your plea offer, and when they reject it later, I have it in my file that I sent them a letter. But the other thing I've done when I have a client who is turning down an offer that I've recommended that they take, or even where I've not recommended they take it, but I want to make sure that they're aware that they have an option to go differently, I will, during a pretrial, simply say, Your Honor, I just feel compelled to place on the record that my client's looking at a 5 to 10 year mandatory, but the Commonwealth has offered a 1 to 2 in the county, and I've advised or not advised as appropriate the client to take that. And I just want to make sure that the client would acknowledge on the record that that's the status.
So it's good to have something in writing that you can prove.
Yeah,
right?
And this becomes an oral colloquy on the transcripts that's available and done in front of the judge so that later, if there's any question, you're protected.
And one last thing, Carl. It looks like this jury on Jodi Arias, they're pretty tough. They've got so much information and evidence. Do you think they're probably going to give her the death penalty?
I think, given the heinous nature of what she did, and given the bizarre behaviors, probably yes. And if she takes a stance that she wants the death penalty, I think that's not going to help her, because I think that's going to take some of the jurors who might go, this woman's just nuts, and I'm not going to put somebody who's that nuts to death. I think that they're going to say, you know what, I can wrap my head around this because I don't feel that bad about a residual doubt because this is what she wants, and maybe she knows she's defective and should be put down.
Well, they're saying she's going to change her tune Monday, though.
Right, well, we'll see. All right, my friend, I'm late for break.
Nice talking to you.
All right, you take care.
When news happens, you hear it first on WHP. Rominger on WHP 580.
All right, well, let's touch briefly on this IRS scandal. Obviously, it's terrible if the administration has misused the IRS in any way, shape, or form. I did hear them pointing out, well, look, we didn't even interfere with any of the large groups. It was just the small groups. But in my mind, that tells me that there was something intentional going on, because somebody's not going to hassle the big groups because they're the ones who will go get the lawyers and go, wait a minute, this isn't right. Something's wrong with the questions you're asking me. Something's wrong with the questions you're demanding of me. Whereas the little groups, the guys that are just trying, 12 guys trying to put together a group, or 50 people in this area, or they're not going to have the resources or sophistication to go, this is wrong, because they don't know what the process was supposed to look like. So to me, the very fact that they're now claiming that, well, we didn't target any of the major patriot groups or Tea Party groups or conservative groups is even more suggestive because, again, if you went after, the NRA's status, for instance, they would have 80 lawyers working on it immediately. But if you got 12 gun owners in Peoria getting together trying to get a little group, and the IRS sends them a letter that says, well, we want to know what kind of Bible you have. Is it King James or the New International Version? They're not going to realize that that's something that they don't have to answer or shouldn't answer. Is just a wholly inappropriate question. It's sort of like a guy or a girl who goes in front of a grand jury without a lawyer and has no idea what they're supposed to be doing in there, but they think they're supposed to be answering questions when in reality they're supposed to be invoking all kinds of other things that their lawyer would do. So don't ever go in front of a grand jury by yourself if you're invited. If you're a witness and they tell you you're a witness, I don't even think they have to tell you that you might be a target either. So be careful. So never go in front of a grand jury without a lawyer, and they have to provide a free lawyer for you if you ask for one. And never go in front of a grand jury with the chief counsel for the Penn State University either, because that doesn't work out so well either. Sandy, you're on WHP 580 with Carl Rominger. What's going on?
Hi, Carl. This is Sandy. My mother is going through this scamming thing on the phone, in the mail, but mostly through her answering calls that she thinks are legit. She's 89. She's just so worried about being broke, her Social Security going away, these kind of things. And about a year ago, she gave out her number to somebody on this telephone call thing, and we had to immediately go to the bank. We were there for like 4 hours, getting everything canceled and getting everything back up and running with things that are automatically taken out of her account, things that, aren't taken out, her pensions, because some people's pensions come from a certain place. You have to show proof of that. It takes months for it to get back to normal. Mm-hmm. So just about when it got back to normal, she did it again. And we went to the bank and we got this all straightened out, and this has been going on for a month.
There is ways to add additional layers of security to those things, but it sounds like she might just give that additional layer of security out if she knows what it is.
Yeah, she does, because as soon as these people call, they say, oh, we're Marilyn Swigert from the bank, and we're just calling to get things straightened out, but we'll need your Social Security number and some digits from your checking account, and so on. First of all, she gets all flustered. She goes and grabs her wallet, and she has, certain places we have her put what she needs.
Well, sounds like she's actually at this point incompetent. And what I mean by that is she's obviously not competent, because if she can be repeatedly scammed the same way.
Yeah. But she'll call us right away and say she got this call.
So, right, and that's like somebody calling up and say, hey, Mom, I just did some heroin every time they do heroin. It's great that they call you and tell you about it so you know, but it doesn't seem to stop them from doing it. So my thought on the matter would be you could, and of course she's going to hate you for it, but you could go see a court and say, hey, we want to take away Mom's ability to run her own finances.
Well, that's kind of what we're in the process of doing. I mean,
it's called a guardianship.
What the bad thing was, we went to the bank on Thursday. My mom gave me a mother's check, and I had gotten her some dirt, Miracle Grow. She paid me for that, and I just wanted to go either get them deposited or cash them. Well, all of a sudden, the bank lady's acting like really weird. We're both looking at each other like criminals. Like we're here to stick the bank up for $30.
Right.
And so what happened was, because her account got flags raised up on it, and we went and went to the bank and talked to them about that.
Hold on one second here. I got our expert here. Oh, I just hung up on that poor lady.
Oh, hey, Carl, it's Dave Mess.
Hopefully she's still listening, because I just hung up on her.
Well, I heard what you were talking about, and in the transition through Art to You, I missed just a little bit about it. But this is a common issue with older folks who, unfortunately, the good news is we live longer. The bad news is that dementia is almost epidemic right now. And you're pretty much on target that at a certain point, older persons lose competency for day-to-day management of bank accounts and are ripe for scammers. So this is the kind of thing that frequently we come in as a third party to encourage our clients, who are always the older persons. It would always be the 89-year-old person in this case. We just try to encourage them to do the right thing and turn things over to their kids for their own protection. So you're on track. And this can be done with the power of attorney instead of guardianship if we get it early enough.
Right. Right, and that's what I was thinking. With the power of attorney, they could change some security words around or something so that even if the principal decided to take action, they would be flummoxed.
Yeah, we've had situations where we've put, I'll pick on Mom, it could be Dad, where we've put their money into a trust and limited the amount of money that they have access to and limited their credit card availability. We have problems sometimes not with scams, but with people. I don't want to pick on any one particular television network, but there are some channels on TV that encourage people to dial up the phone and buy something constantly. So we see that one as well as scams that are outright fraud.
Yeah, they're just so tempted to go ahead and now wait a second. Let me get this right this time. I'm going to lock you. And Sandy, you're back on with Dave. Were you hearing what he was saying?
I kind of caught the tail end of it, and only because, yes, we've been over all of this, and both my husband and I have power of attorney. And it's not like she's not going to be able to be persuaded because of all this happening. I keep telling her, we just want to take away these things that are interfering and causing you discomfort. We just want you to be happy. And we have our money, you have your money, but we're going to the bank Wednesday. We're definitely going to have to get this straightened out. But what I was really calling about, would you suggest changing a phone number to get away from this certain group that keep bugging her?
Well, I would say absolutely on that. Dave, what did you want to say?
Well, I don't know. I don't know about changing the phone number. First off, I just want to commend the daughter. I did not pick up your name, but your mother's very lucky to have you, because when you do the things you're doing, commonly a parent will get quite upset. And it's not always easy to be the responsible adult child and be the popular one. So good for you for doing that.
It's really hard. It's really hard.
Good luck, Sandy.
Carl,
Sandy.
Thank you. Thank you for your help.
Dave, I got to go.
We're going to have a seminar this Thursday I wanted to tell you about real quick at the Hampton Inn in Ross Moines. 10, 2, and 7 will be covering this and more topics.
Can you hold on till after the break, and we'll
do.
All right.